confidentiality, and the best interests of the state. Bizarrely, however, the district has not raised any of those three defenses. Rather, the district has raised four alternative affirmative defenses to justify its denials in its response to our complaint, and those were failure to state a claim upon which relief can be granted, that the district is immune from the lawsuit. They raised the equitable defenses of estoppel, waiver, latches, and unclean hands, as well as the statute of limitations. But none of those defenses applies here because to overcome the presumption of disclosure, the district must specifically demonstrate how one or more of the recognized exceptions applies to each specific record requested. At issue in this case are 6 very straightforward public records requests. There has been no demonstration or even an allegation of anything specific for any one of the 6 requests, let alone each of the 6 requests. In fact, even on the most charitable interpretation of the district's defenses, there have only been general, vague reasons submitted to this court for denying the requests. For example, in paragraph 27 of the district's counterclaim, the district expressly submits to this court, Your Honor, that it, quote, has and will continue to deny plaintiffs access to overly broad and voluminous requests. Yet the Arizona Supreme Court has rejected using a blanket rule exempting categories of documents from disclosure. That was in the Cox, Arizona Publications, Inc. v. Collins case. So it is the case that either the district has not articulated any legally cognizable reason for denying the requests, or whatever reasons have been articulated are insufficient to overcome the presumption of disclosure. For example, the first request is for district emails with other government agencies on specific subjects related to the district's operations between a specified time frame. Another request at issue here are invoices for the fiscal years from 2004 to 2007, and so on for the rest of the requests. All the requests at issue in this case, Your Honor, are public records under the law, and the requests are sufficiently specific that the district knows what records to produce or could easily work with the plaintiffs to determine what is being asked for. However, rather than comply with the law, the district, seemingly with pride, has told this court that it will not produce any of the records that are at issue here. The district describes this lawsuit as, quote, a veiled attempt to further harass the district and, quote, a blatant scare tactic calculated to pressure the district into releasing otherwise exempt documents. Notably, Arizona courts have recognized that it is well established, and I'm quoting, that the requester's need, good faith, or purpose is entirely irrelevant to the disclosure of public records. There is simply nothing in the record here, Your Honor, that can overcome the presumption in favor of disclosure. The rule is that the custodian must demonstrate specific harm for each record requested, and the district has not even come close to doing that in this case. Therefore, this court should order the documents be disclosed. With that, Your Honor, I'd like to move on to the counterclaim, if that's all right.
Sure.
I'd like to address that. The district's counterclaim asking this court to issue an injunction against harassment against my clients, Your Honor, is a bad faith attempt to prevent my clients from exercising their constitutional and other rights afforded under federal and state laws and constitutions. There is no basis in law for this counterclaim, and it should be promptly dismissed. Such an injunction would unconstitutionally chill not only my clients' rights, but also those of the general public, particularly the residents of the district. People would rightly fear that requesting public records from the district, that's something that they would fear, and they would have reason to avoid expressing their views about the government, particularly on the internet. The only 3 types of harassing acts alleged by the district in this case are placing 100 or so records requests over the course of 3 years between 2 people, which is an average of about 15 requests per year per person, filing complaints with the Ombudsman and the Attorney General against the district, and maintaining a website that is critical of the district and that facilitates residents of the district to request records from the district. Given the district's behavior, any resident of the district should fear placing records requests with the district, should fear filing complaints against the district with other government bodies, and should fear expressing their critical views of the district. Why? Because if they do any of those 3 kinds of things, the district might sue them, as happened to my clients here. The injunction against harassment, if issued, would violate the plaintiff's rights, would conflict with the district's legal duties, which are mandatory under the law to disclose public records,